Hello, my name's Steve Thompson and I'm a partner at Darwin Solicitors in Cardiff. I'm going to talk to you today about some basic legal concepts surrounding setting up a business. I'm just going to share my screen with you now so you can see some slides that I prepared earlier, so just give me a moment to do that. So the idea really is to sort of talk you through a few legal issues, which are the kind of key things you need to think about when you're thinking about setting up a business. There's obviously lots of considerations. I'm going to touch today on some of the sort of headline ones. So there I am. I'm managing partner and also look after corporate commercial team at Darwin Gray. So in that capacity, I spend a lot of time advising clients on the kind of legal issues that they need to think about right at the start and during the journey that their business will undertake. So I'm going to kind of go through a few of the key ones today. I think one of the first things that you need to think about when you're thinking of starting a business is what's your trading style going to be? And what I mean by that is what legal entity will you adopt when you trade? One of the ones that people often pick is a sole trader, particularly if it's going to be a small business because the accountancy requirements are less and it's just a bit less complicated and tends to be a bit more cost effective. But there may be more than one of you, and if there's more than one of you, depending on the kind of business that you have, you might want to look at a partnership. Most people will have heard of a partnership. They're quite sort of informal arrangements. You don't need to have a partnership agreement. You can just start up doing whatever you do. The other option is an LLP, a limited liability partnerships. Now, those tend to arise in a professional practice type situation. So if you're maybe a firm of solicitors like we are, you might find an LLP will be appropriate. And one of the benefits of an LLP versus a partnership is with a partnership, generally speaking, all the partners are jointly and severally liable for each other's action, which might be great if you're doing some sort of commercial enterprise. But if you're providing professional advice, and there's lots of liability attached to it, you might not necessarily want to be liable for any mistakes that your partners make, even with the benefit of professional indemnity insurance. The benefit of an LLP is that there's a separate legal entity, which is the limited liability practice, and basically all of the members of that are effectively the partners. The most common is probably a limited company. I think most people who start off a new business who've got, particularly if you've got a desire to grow it and maybe get funding, really you're probably going to be going down the limited company route. So I'm going to spend quite a bit of time talking about that. The thing to think about with a limited company as well is you need to have in mind the idea of what's called pre-incorporation contracts. So you need to be careful that when you start trading, you don't start trading too early. If you enter into a contract before you're incorporated, then you might find that you are personally liable for that contract. So you just have to be slightly careful. If there's any major contracts that you're proposing to enter into, make sure that company is incorporated before you enter into them. Make sure it's clear on the contract that you are entering into that contract as a limited company on behalf of the limited company. We often see contracts that come to us where there's been a bit of an argument over who's liable. And the reason for that is because people don't necessarily make it clear in the contract. Make sure the full name of the company is recited in the contract. Make sure that it's clear you're signing on behalf of the contract as a director. So there's no argument at a later date that you're somehow personally liable. Because in some more informal situations, I've seen many examples where people have been involved in trading activity, and then if the company goes into liquidation, then you might find that if you've been a little bit relaxed and slapdash about how you enter into your contract, that somebody might try and say that you're personally liable for some money that is owed to them, which isn't really ideal if your company's gone into liquidation. So the first thing to think about is the stakeholders. Now, these are really the business owners. So partnerships, so really what you want to think about is regulating your relationship between you. So in relation to a partnership, you'll want to have a partnership agreement. You don't have to have one, but it's advisable to have one. And that agreement will basically set out the basics of the partnership, who owns what, who's got power to do what, and all the rest of it. An LLP agreement is the sort of agreement that you would need if you're setting up an LLP. So that's much the same as a partnership agreement. That sets out basically the bits and pieces of how the business is going to be run. And then in relation to limited companies, the rules of the company are what's called the Articles of Association, and they're quite often in the model form. If you set up a basic limited company, you'll have the model articles, which will effectively be the rules by which the company will be run. And you can get by without a shareholders agreement. So you could run a limited company for a number of years based on simply having the articles. But I would always advise, if you're going to really go anywhere with the company, particularly obviously if there's only one shareholder, you don't need to worry about it. Or maybe if it's husband and wife, you might not really want to worry about it. But if you're stakeholders, if you're co-shareholders, if you're all individuals, you probably want to think about having a shareholders agreement in place, because that agreement can regulate the relationship with you. And certainly in a limited company, that's quite an advisable thing to have. So just thinking about what could be in the shareholders agreement, there's a lot that goes into it, and these are quite long agreements. They're usually drafted by a solicitor. You would certainly want to have professional advice on them, because quite often if you kind of download something off the internet, you might find out that you're worse off than if you didn't have it, because you'll have ended up signing yourself up to a load of clauses which are really unhelpful to you further down the line. So I've listed on this slide a few things that you might want to think about having in the shareholders agreement. So top one there is dividend policy. So you can specify in the shareholders agreement what that policy is. It might just be to pay out everything you can, but you might want to be a bit more specific about it, particularly if you've got more than one shareholder. You also want to think about rules around the transfer and sale of shares. This is quite often a tricky one, where at the beginning everybody's singing from the same hymn sheet. They're both quite happy to sort of move the business forward. But it may be that further down the line that actually you want to be able to get out of the business. People have different life priorities, and it's quite important that you cater for that, and that basically you think about that. It's always worth thinking about that kind of thing at the beginning, as opposed to when the time comes, because at the beginning, when nothing's really worth anything and everybody's quite happy with everything, that's the time you can get things agreed. Excuse me. The other thing to think about is what happens on death or incapacity, particularly death, because it may be that you don't necessarily want to end up with your co-shareholder's spouse as a partner of the business. So you need to think about what's going to happen if a shareholder dies. Do their shares get bought back by the company? Do they transfer to the other shareholders? Or what happens? And what happens if that person becomes incapacitated, if they're long-term ill? What happens with their shares? Are they still going to get dividends, or what's going to happen there? The other thing to think about as well is restrictive covenants. So what you can provide for then is somebody exits as a shareholder, that they can't just take the business with them, because if you don't have those restrictive covenants and somebody resigns as a director, then they can basically set up next door to you and nick all the clients of the business. So having those restrictive covenants in will protect the company. And you do need to think about it like that. You need to think about protecting the company and not your individual interests. You can also have something called drag and tag along, and these are clauses which enable a drag along clause would enable a majority of the shareholders to force the minority to basically sell to a third party, and tag along is the reverse of that. So if you're the minority, you can insist that the majority sell your shares to a third party if they're selling their shares. It's quite common to have those kind of provisions where you have an imbalance of shareholding, or whether you have more than one shareholder. It just means that from a corporate governance perspective, that you can, if push comes to shove, you can actually get a deal over the line. Just mentioning corporate governance, you can set out in the shareholders agreement the kind of decisions that need a majority approval. You can set a percentage of shareholder approval which is required for certain decisions to be made. And it's quite common to have a schedule at the back of the shareholders agreement with the kind of things, kind of key decisions that can be made only with a certain percentage of the shareholders being in agreement. And the other point there at the end, business protection insurance, really that's something to think about taking out at the point when you enter the shareholders agreement, because it's relatively inexpensive insurance that can pay for the buying back or buying of shares when somebody dies or is incapacitated. So going back to that point about death or incapacity, it's all very nice, the fact that you have the right to buy shares off an incapacitated or long-term ill shareholder or the spouse of that person, but how are you going to pay for it? And that business protection insurance will help you with that. So those are kind of a list of a few things that you could have in a shareholders agreement. By no means all of them, but those are the kind of key things, which gives you hopefully a flavour of the value of having a shareholders agreement. The other thing to think about is your employees and other staff. Obviously, contracts of employment you'll want to have with those staff. I'm not an employment lawyer, but these are sort of just the key things to think about. So basically, you'll want to think about having proper contracts of employment with your staff. I mean, there's a legal requirement to set out their terms of employment in writing, but certainly a contract will enable you to include other provisions such as restrictive covenants, confidentiality clauses, that kind of thing, just to protect you, because it's all very nice when everybody's happy, but you only need one rogue employee and all of a sudden you've got a problem on your hands. And if you've got a properly drafted contract of employment, it's going to put you in a much stronger position. Director service contracts, these are effectively employment contracts for directors, so you might want to think about having those in place, because again, they enable you to regulate the position in relation to that director, because without them, apart from sort of the standard statutory and common law duties as directors, you won't really have a great deal to fall back on if you find that a director goes rogue. But if you do have director service contracts, then you can have a lot more in there, again, things like restrictive covenants, that kind of thing. Think about consultancy agreements. So if you've got consultants or third parties who work for you, have contracts with them as well, because again, you can include all the usual stuff about confidentiality, restrictive covenants, ownership of intellectual property is another big one, which I'll touch on a bit later. And then all the general stuff about HR, staff handbook and other policies. And also think about health and safety, which is the last point there on the slide. So those are just a few things to think about in relation to employees and other staff. But then thinking about terms of business, this is quite important. This is your relationship with your clients and your customers. So you need to think about having these in place. So you want to think about making sure that you've got formal contracts in place with your clients and customers. That might be terms of business, it might be service level agreements, it might be letters of engagement. But you do need to make sure you have something in place, because if you don't have those sort of things in place, then no matter whether you're selling goods or services, you are exposed, particularly if things go wrong. So the sort of things you need to think about are the sort of risks and liabilities of what you do. As I say, those can be in terms of business, the sort of T's and C's that are on the back of order forms, or it might be a longer contract. The important thing with these terms of business is that you need to make sure they're incorporated. There's no point in having fantastic terms of business if they're not actually incorporated into the contract. So that's always something to be aware of, to make sure that when you're entering into contracts with people, that they've had sight of them, or you've got them properly incorporated. And again, your solicitor can help you make sure that you achieve that. If you're running an online business, then you'll probably have a click wrap arrangement or some other way of people acknowledging the fact that they're agreeing to them. And also behind those, you might have some insurance. So you might have, if you're selling products, you might have some product liability insurance. Or if you're selling professional services, you might have professional indemnity insurance, but that will sit behind your terms of business. But really, you want to have both in place, because you can do an awful lot for yourself by having decent drafted terms of business. Just a few things to think about that can go in those terms of business. So there's a little list there. So obviously payment is a good one. So you can have payment terms, the amounts and the timings and all the rest of it. You can also provide for what happens if people don't pay, whether they're going to be subject to interest. Also think about time of the essence. It sounds a bit weird, but if you're providing services, you might want to make sure that just because you miss something by an hour or a day, that you don't get hauled over the coals for breaching the contract. So you can disapply that and say time isn't of the essence. Particularly in the construction world, that's something that's quite important. You can limit your liability, which is really important. So if something goes wrong, people can't sue you to the end of the earth. You can limit the liability that you have to your clients and customers. That's a really important one. Also, intellectual property, you might want to think about ownership of that, depending on what you're doing. If there's a lot of IP in what you do, then you want to make sure that, as between you and your clients and customers, that the IP ownership is clear, and that you can't have allegations made at a later date that they somehow own some of the IP that is yours. Also, you can provide warranty. So if you want to provide a particular warranty, then you can put that in there. So maybe a 12-month warranty, whatever you want to put in. And also force majeure, the old favourite. Nobody had heard of force majeure really until about a year ago, when COVID came along and everybody was reaching for the more force majeure clause to see if they could get out of a contract because of COVID. And before then, nobody had really shown a great deal of interest in it. But it's something that's worth thinking about. And if you have a force majeure clause in your terms, you might want to make sure that it does include a reference to a pandemic, because obviously that's something that's now very much on everybody's horizon. So just touching briefly on consumer regulations. So if you are dealing with consumers, you need to think about the fact that there are consumer regulations out there. There are certain things that you are obliged to provide. Stated there, your legal identity, total price, how to be calculated, and also cancellation rights are really important with consumers. They also have a cooling off period, and you need to be aware of all this kind of stuff, because if you trade with consumers and you don't have this stuff boxed off, then you might find out that you'll be in trouble with your local trading standards or other organisation, because they are regulations in place to protect the interests of consumers. And if you don't get pieces of paper in the right place, then you might find out you get penalised just for not following the rules, let alone actually not providing compensation or whatever is due to people. So if you are selling to consumers, you do need to get some advice on that to make sure that you've got all the I's dotted and the T's crossed. Just a quick word about Brexit. Obviously, we've got little thin deal, as they say now, and there's a few issues arising out of that. It's probably going to be only of interest to you, obviously, if you're trading outside the UK. There's certainly export issues. If you're importing or exporting goods, you'll need to think about those tying to the origin of goods. It's not really I'm not really going to get into this now, but you need to think about those. Also, if you're employing anybody from Europe, you need to think about that situation as well. Certain types of service, if you're offering a service into Europe, certain types of service will need special sort of, excuse me, special types of consent and agreement from whichever member state you're trying to sell them into, and also recognition of professional qualifications. In some member states, you'll need to make sure that you're complying with the relevant rules. So it's just something to think about. If you are going to be selling into Europe, you do need to think about what the position is. Just going to talk about data protection as well. This is something that I think everybody a couple of years ago got very excited about, GDPR. And although we're now out of Europe, the GDPR is still relevant in as much as equivalent rules are in place in the UK in the form of the Data Protection Act 2018. So a couple of things you need to think about. You need to think about your privacy policy, and you'll probably have one on your website, at least you should do, and it needs to be GDPR compliant. So if you did it 5 years ago, or you got it from somebody else who did it 5 years ago, it's probably not going to be compliant. So that needs to be done properly. You may have an internal one for staff as well, ideally. If you're doing anything that involves significant amounts of data, so if you're processing a lot of personal data, then you do need to think about risk assessments and impact assessments rather, to make sure that you really thought about what data you're processing. And in certain types of business are legally obliged to have a data protection officer, or not, you might need to think about having a data protection manager. So do think about data protection, think about what personal data you're processing. It's only going to be relevant if it's personal data, so it's data from which you can identify somebody. Most businesses are going to be processing some sort of personal data. At the very least, the absolute bare minimum, you will need an external privacy policy on your website, but you do need to think about data in a sort of bigger way. Just moving on from that, in terms of online businesses, these are the kind of things as an online business that you'll need to think about. There's a huge growth in the world of online businesses. Obviously, as we all know, the demise of the high street with COVID has been sort of sped up, and the growth in online businesses has been astronomical. And when you're trading online, you do need to think about certain things in particular. The first one there, terms of business, you do need to think about that in the same way as with any other type of business. So you want terms of business that you'll want to have with your consumers. It can get a bit complicated with online businesses, because if you're providing some sort of market platform and you're allowing other businesses to sell through your website, it may get more complicated, because you may need terms of business with end users and terms of business with suppliers or people who use your marketplace. So it can get a bit tricky. If you're just selling goods on the website, then it's the same types of terms of business you would use if you were selling to the general public from a location, maybe a shop or what have you. But you do need to think about that and think about the relationships between the parties. Also, you'll want to think about website terms of use and acceptable use policy, and then a cookie policy. So those are the kind of basic things. Most lawyers in the kind of commercial world should be able to help you with those. Just touching now on intellectual property. So this is a big area that we advise clients on. So if you have the kind of business, as most people do, where there is some intellectual property involved, you need to give a bit of thought to that. It may be no more than just making sure that you have protected yourselves with regards to your clients and your terms of business and your employees and your contract of employment. But you do need to think about IP, and a lot of businesses don't really give it a great deal of thought. And what they quite often find is that they'll end up with a business where they haven't really identified the IP or put any value on it. What that means is it can be selling themselves short when it comes to selling at the end of the day. So it's really worth giving some thought to your IP. Start with a blank sheet of paper and really work out where that intellectual property is. You may need a bit of help, which is where an IP audit comes in. The Intellectual Property Office in England and Wales will do sponsored IP audits. They're quite a useful tool. You'll get assistance from a lawyer or another intellectual property professional to help you with that. And that exercise will enable you to identify what your IP is and to think about how to protect it, and also to value it as well, because most IP will have a value. And you need to think about pre-incorporation IP rather. If you have got that limited company and say you've got 3 or 4 people who've got together and brought their skill sets, it might be that 1 or 2 of them have been doing a bit of pre-incorporation work, and that you need to make sure all that IP is actually within the business. So do think about that. Make sure that if you've got, say, 3 or 4 shareholders who've come together to start a company, and one of them's already been working on something, make sure that that IP ownership is properly transferred into the company, because you can easily transfer it with appropriate agreements in place to make sure that that person doesn't try and argue down the line that, well, some of that still is owned by me. You need to make sure that everything is in the pot. So just thinking about the types of IP that you might come across, obviously TM, trademarks and logos, everybody's heard of that. Most businesses are going to have a logo or a trademark of some sort. There'll be copyright in there. If you've got a website, there'll be copyright in the text of the website. You might have design rights. So if you produce anything, that might well have design rights attached to it. If you manufacture something, then you'll probably have trade secrets. So you might want to think about those and how you're going to protect those. Trademarks and logos, as I mentioned in a minute, can be registered. Trade secrets, not so much. And it's more about protecting them and making sure they don't fall into the wrong hands. And then patents obviously is something that you may or may not be interested in. If you're a small business, and unless you're in the business, unless your stock in trade is inventing things, you're probably not going to be worrying about patents too much. But it's useful to know that they exist. And also databases, there are rights in databases. So if you have a kind of business that trades in information, you might find actually you have some ownership rights in those databases. So those are kind of typical types of intellectual property that you're going to come across in your business. And these are the ways to think about how to manage and protect it. So when you're engaging with third parties, always make sure that you've thought about where the IP ownership is. So if you're using a designer or a copywriter, make sure that at the end of the job when they've been paid, that the rights are going to get assigned to you. Quite often they'll sit with some rights in that work will sit with that designer and copywriter and stay with them. And further down the line, when the IP becomes really valuable, you won't be able to get that off them without paying them a significant sum of money. And there are a few horror stories out there about those kind of things. Keep an eye and check the competition, see what they're up to. Make sure they're not nicking your ideas. Register IP when you can. You might not want to be registering trademarks every 5 minutes, but certainly your key intellectual property, your key logo and trademark, it's always worth registering that. Because I think when it comes to sell the business, it's a nice thing to be able to show that you've done, and it kind of adds a bit of value to it. I think user symbols, they don't necessarily create a lot of legal value, but certainly it's worth sort of warning people off. And make sure that when you've got contracts with your clients and customers, that again, it's clear where the IP ownership lies, and also the same with stakeholders and employees and consultants, as I mentioned earlier. Just thinking now about funding and investment, obviously as things go on, you'll need to obtain money and funds for the business. So thinking about debt equity, so debt obviously is typically going to be loans and overdrafts from a bank or other funder. Then you can get into factoring depending on what you do. A lot of business sectors use factoring quite commonly. And then think about security, because some of this will require you to give up security. So you might have to give a personal guarantee or an overdraft or a loan, and also the company might have to give security. Typically, if a bank's loaning money or giving an overdraft, they'll want a personal guarantee. If it's a new company, they might want a personal guarantee from a director. It might have to be backed with a legal charge over a property, and they might want a debenture, which is a legal charge over the assets of the company. In terms of equity, so quite often businesses have family and friends money at an early stage, which is all very nice when they just give you some cash and you spend it, and it's on a sort of vague promise of shares. But always get the paperwork done, because further down the line, this is on to the next point about forward planning. One of the investment mistakes people make is they dish out a lot of shares early doors, and they don't think about it, they don't take advice, and they suddenly find that when they want to get some real money in, that the problem they've got is they've given away so much of the company already, and they've not even properly regulated it. So it's worth thinking about things in advance. These are the kind of places you can get money from. So obviously business angels, those are maybe people just floating around town. They often get together and you'll be able to pitch your ideas to them. A little bit sort of local version of Dragon's Den. I've got DBW on there, Development Bank Wales. Obviously, we're in Wales, and they are a key equity investor in Wales. Venture capitalists also. Just a couple of other things here to think about in relation to funding and investment. Vesting schedules is something to be aware of. So if you're promising shares to employees, key employees, you need to think about when they get those shares. So give that some thought. Make sure that's properly documented. So you might not want everybody to get everything on day one. You may want them to sort of work for a bit and get that further down the line. And also think about investment agreements. So if you're getting investment money from, say, DBW, they will want you to agree to an investment agreement, which is quite a chunky document and will require some legal advice. Alphabet shares, typically, so A, B, C, D shares, that kind of thing. So you might want to give shares away with different rights. You don't have to give the same type of shares to everybody. Certain shares may have different rights attached to them. Maybe certain shares won't have voting rights, and also employee share options. So those can be done formally by way of a tax efficient scheme, or more informally, where you just basically agree to give somebody some shares. So just a couple of other things to think about, just to finish with. I'm not going to cover these today. Property is one thing to think about. So early on, you may be working from home, so you don't have to think about that. Or you may be using a easy in, easy out type of business hub. So that's probably quite low key, but at some point, you're probably going to take, if you're successful, you probably take an office somewhere and you need to get a lease looked at. You might buy somewhere. So that's something to think about. And then obviously tax. We don't advise on tax, but people do, and you need to think about that. So it's really tax and accountancy advice. It's not really a kind of a legal thing, but it is something that you need to think about. So I think the earlier you kind of get your head around that, the better. So that's my whistle-stop tour. Apologies if it's quite quick, but I just wanted to give you a heads up on a few areas. There's quite a few things to think about. I think the important thing is really just to probably sit down with a blank sheet of paper and just sort of go through everything gradually and make sure that you have really sort of thought through all the various issues. You don't necessarily need to think about everything on day one, but you might want to make sure that when it comes to it, you've at least been through the list. Because I think if you took those slides that I've just shown you and you went through them and you made sure that you looked at each individual aspect, I think you could do a lot worse than doing that. And hopefully what that will mean is that you will then have boxed off all of the things you need. So best of luck. Please get in touch. If you'd like those slides, please get in touch with us using the email address on the slides, and we'll be happy to send it to you. Thank you.